All right, this is case number 22-185-143. This is Progressive Michigan Insurance Company versus Netta Thomas. Matters before the court settled for review on today's date. Your appearance for Progressive, please.
Good morning, Your Honor. Naljat Francis on behalf of plaintiff's attorney of record.
All right, thank you. Counsel, you put your P number on the record, please.
Oh, sorry, P72322, Your Honor.
All right, thank you, Counsel. Do I have Netta Thomas on the Zoom? Please say something if you're here.
Yes, yes, you do.
All right, thank you. Good morning to you, Ms. Thomas. I adjourned this matter for review to check on the existence of insurance coverage. I believe that there was an issue as to whether or not Ms. Thomas had insurance available regarding this claim. Ms. Francis, can you update me regarding this matter, ma'am?
Your Honor, we did contact the insurance company. We also followed up with another letter. Let's see, the last one was on 9/28 as they requested a claim number. We provided them the information they requested. However, we have not heard back from them since, Your Honor. So at this time, I believe I would request just another adjournment to let them have time to respond back to us.
Ms. Thomas, that makes sense to you as an adjournment because it seems that there's some exchange with the insurance company, but we haven't got to the bottom of that yet. So that makes sense to you, ma'am?
Yes, we did have insurance, so I don't know what their problem is, but yes, sir, it does make sense.
All right, so I'll go ahead and grant another adjournment regarding this matter, and I'll again set it for review. So, Ms. Francis, you think another 30 days would be sufficient?
I would hope so, Judge.
All right, so I'll keep it close and bring it back in about 30 days. So that's going to be November.
November. Yeah, we have those other dates. So if you want 30 days, you got to go to the first week in December. So December 5th.
December
5th.
5th. 12/5 actually is going to be the date 12/5/22, and that's going to be at 9:30 a.m. December the 5th will be the next action date. And again, the matter is adjourned for review. The court finds good cause for the adjournment under the circumstances set forth on this record. All right, so see you at that time. Good day.
Thank you.
As well, man.
Thank you so much. Thank you.
The court now calls case number 22-188-992. This is Daisha Posey versus Gold Key Real Estate. The matter is before the court. Settling for a status conference. The court is in receipt of the answer. The matter is joined accordingly. Your appearance for Daisha Posey, please.
Morning, Your Honor. Ken Demers appearing for Daisha Posey.
Your P number, if you will, Mr. Demers.
P49605. Thank you.
Thank you, counsel. Good morning to you, sir. For Gold Key Real Estate, please, your appearance, counsel.
Good morning, Your Honor. Joshua Castmore, P76326 on behalf of Golden Key.
Thank you, Mr. Castmore. Good morning to you, sir. So as I mentioned in the prelude, I see that the matter has been joined by contest. Looks like this has something to do with a was it a sell, a purchase of real estate, or is this a lease, after lease type situation? Somebody update.
It's a security deposit issue, Your Honor, following a residential lease.
Yes, Your Honor, that it has to do with a voluntary termination of a lease and some dispute arising from the surrender of a property and a balance of amounts due and some dispute arising from, what's due at the end of the lease and return of a security deposit.
Got it. All right, and so I see one document where the claim is that the amount due is some $1,210. Is that what's sued for here, counsel?
Your Honor, we were suing under the Security Deposit Act. However, there are a couple of things that come into our operation here. The defendant, Gold Key, seems to be invoking a early termination, which we're falling back on some proofs where some conversations were taking place without going into too much detail, leading up to the termination of the tenancy where our client was let out of the lease where, voluntarily where the early termination fee wouldn't be applied. So I think there's enough wiggle room where we might be able to come to some kind of a resolution here.
So, and that's kind of what I was driving towards, just looking at this, but I do know how thorny deposit issues that lease-in type issues can get, and not so much oftentimes because of the lawyers, but because of the actual litigants. You think taking a moment, the two of you talking about this to kind of see if that is bottom line. So I do have a breakout room. We can take a moment to try and do that. And if you need the court's engagement at all, I will try to do what I can to assist. But why don't we take a moment to talk about it?
I think that would be a good idea, Your Honor.
I agree.
I'm going to send you notification for breakout room number 1. And I'll stand down. I'll be on the other side of this. Okay? All right.
Thank you, Your Honor.
Okay, thank you, Your Honor.
Deborah, you good this morning?
Yes, good morning, Judge.
Hey, Deborah.
Oh, hey, Tifa, how you doing?
Okay.